Yeah, you can start now. Hello, Carla. Namaste.
Hello.
Sorry, we are just asking the other panelists also to join. So sorry for the little delay.
No, no worries.
And very good morning to you.
Good morning. Good morning.
What is the time now?
Here, 4:47 a.m.
Oh no. So Yon is joining from Japan. Yon Fernando and Maria Paula is joining from Rome. There is some problem with Fulman Chaudhary because he is staying in a village where there's no electricity. But Namrata, I requested Namrata, our Indian colleague, to join from here. So we are 4 people from 4 different continents.
But that's exciting. Hopefully, the logistics work out. But no worries. I'm here. No worries.
Yeah. So maybe very soon we'll connect to everyone. Huh?
That's fine. That's fine.
Yeah. Hello, hello, Maria. Hello, Maria.
Hello, can you hear me?
Yes, I hear you. Namaste.
Okay. Namaste, namaste. How are you?
I'm fine. So Carla is also on board. So Carla
Okay.
is actually, she's in Washington, DC. And I just gave a lot of pressure for her to woke up very early morning, 4:30. So, and
No.
can you, yeah, sorry, please, Carla.
No, I was going to say no worries, no worries. I'm here. Good to hear you, Maria.
Hi, good morning. Early
Good
morning.
Good morning.
Yeah, good morning.
Maria, can you just quickly check with Yon because I just text quite a few times, but no response. So
Because he's on mission in Tokyo, but he
Yeah,
told
yes.
me that he would participate, so I will send
yes.
him a message. Yeah, let me check.
Perfect. So I'm just waiting for another speaker, and then maybe in 2-3 minutes we'll start. Okay.
Great.
Thank you.
Great.
Ramesh Yon is joining. He's just responded to my message.
So just we'll wait for a minute, another minute, and then we'll start.
ST. Only ST is 40. All displaced. Displaced or deprived. From 1947 to 2010, 60 days. Displaced, they are frustrated, so to say. Yes, some of them. So from all the research. Land acquisition cases are getting. Yes, land acquisition of land takeover because much of it is not required, it's just taken. Check the CPRs, they're not required, they say it's straightforward, they took them. That's all land cases. No, this is not disputed. They say it belongs to the state or common land. And the private land is predominantly. Yes. Yes.
So yes, hello, welcome to all of you, and good morning to Carla because she is joining from USA. It's around 4:30 or 4:45 in the morning. So Carla, good morning to you. Jan, good evening to you because you are joining from Japan, and I know that you are in a mission. And thanks for your time. We have Maria Paula from Rome, AKO. She works in the land tenure division. Maria, I think it's good morning or good afternoon to you. And we have our very special speaker from India, Namita ji, and I have requested Namita ji in the very last hour because Sulman Chaudhary is unable to join because of some connectivity issue. So welcome Namita ji. You are a part of Land Rights Initiative in Center for Policy Research. So friends, this is a session which is actually devoted on one very interesting topic, which is close to our heart, that what are the international frameworks available on the land rights and how to protect the rights of the indigenous people as well as the other landless community, especially with the reference of international tools, international frameworks, international conventions, or international policies. So let me begin with kind of a core reference, and then I would like to invite each of the speakers to give 8 to 10 minutes, and then we'll open for some other question answer. So the first reference, and very important reference for all of us in consideration of the international framework on land rights, is the Article 17 of Universal Declaration of Human Rights, which actually talk about everyone has the right to own property alone as well as in association with others. The second very important reference for all of us is the connection between the cultural rights and the land rights, which has been acknowledged by the Human Rights Committee in its interpretation of Article 27 of ICCPR. So the third and very, very important reference for all of us is the land rights and cultural rights for indigenous people has also been the core of recent decisions and interpretation of American Court of Human Rights. In the year 2001, in the case of Awas Kenyani community against the Nicaragua, and the court stated very clearly that indigenous groups, by the fact of their very existence, have the right to live freely in their own territory. The close ties of indigenous people with the land must be recognized and understood as the fundamental basis of their culture, their spiritual life, their integrity, and their economic survival. So this is another third and very, very important reference point for us today. The fourth reference for us is that the reference to the cultural integrity found some echoes in the recent decisions of the African Commission on Human and People's Rights, ACHPR, in the case of concerning the Indorese community in Kenya. And even in this decision, the decision said it very clearly, the African Commission received a claim to cultural integrity by acknowledging that the removal of indigenous community from its ancestral land was a violation of their rights to cultural integrity, based on the freedom of religion, Article 8, right to culture, Article 17, and access to natural resources, Article 21 of the African Charter. And this is a fourth very interesting and very, very important reference point. The fifth reference point for us today is a parallel lawmaking effort that culminated with the adoption of the UN Declaration on Rights of Indigenous People in 2007, which has amplified the jurisprudential evolution. So Article 25 is a very clear, and it is actually given a very interesting picture that indigenous people have the right to maintain and strengthen their distinctive spiritual relationship with their traditionally owned and otherwise occupied and used land, territories, water, coastal lines, and other resources, and to uphold their responsibilities to the future generation in this regard. So these are the 5 very, very interesting reference points for us today. So friends, today we have a very eminent speakers in our panel. So first, I would like to invite Jon Fernandez de Lorena, who is heading the Indigenous Division in the UNFAO. He is based in Rome, but roaming around the world. Today he is in Japan. Last week he was in Kenya. And being a leader of Indigenous Division, he has done an excellent work. He's very instrumental to help the movements, to help the different research institutions, international bodies, and different governments. Even in India, he's associated with some of the groups who are working on the Forest Rights Act. So, Jon, the 2 questions to you that especially indigenous people have a right to maintain their practice and their distinctive spiritual and cultural relationship with their traditionally owned and otherwise occupied and used land, territories, water bodies, etc. For the future generation, today the challenges is the most of this southern world inherit and executing the colonial law, which are persistently against the rights of the indigenous people. So 2 questions to you. The first is, where do you see the scope and success of international framework to institutionalize and protect the ownership rights of indigenous peoples, especially for their ancestral land and resources? And our second question is, how a country can decode the international framework into domestic laws and policy and protect the rights of the indigenous people? And is there any good example to learn and adopt? So over to you, Jon. Thank you.
Well, namaskar, Ramesh and Dhanyavad. Thank you so much for the invitation. We feel humbled to be in the Indian Land Development Conference. Extremely important topic. Let me introduce myself. My name is Jon Fernandez de la Rinoa. I'm the head of the FAO Indigenous Peoples Unit. Can you hear my audio well, Ramesh? Yeah, excellent. Thank you so much. I'm in the middle of a conference in Tokyo. We are talking about nutrition, but the issues of territory, land, natural resources, and indigenous peoples are really up in the agenda. Now, why is this? I would like to divide your first question, if you allow me, Ramesh, into 2 parts. The first one is on the scope, and then we will talk about the successes of the international tools. I think there is tremendous scope because there are a number of international tools and that already inform the importance of territories, lands, natural resources for indigenous peoples. Of course, we have the voluntary guidelines on the right on the governance of the responsible governance of land. But my colleague Maria Paula, I'm sure that will expand on this. But if we go back, we also have, of course, ILO 169, already talking about indigenous peoples and the importance of this convention to preserve the heritage and the knowledge of indigenous peoples, already based on the free, prior, and informed consent. Following on that, we have the UN Declaration on the Rights of Indigenous Peoples. Several articles about on the UN Declaration on the Rights of Indigenous Peoples already talked about the importance of indigenous peoples to have secure access to their lands, territories, to preserve their livelihoods, and to continue with their food systems. But if we looked in 2004 at the voluntary guidelines to the right to food, this is 3 years before the UN Declaration on the Rights of Indigenous People. The voluntary guidelines on the right to food were adopted by FAO, by the conference and the council in 2004. And already was clearly established that for indigenous peoples, what you call Adivasi in India, for them to have the right to food guarantee, we need to ensure that their access to their territories and ancestral lands is guaranteed. So that connection between land, food security, well-being, indigenous people's food systems, And I will say now in the context of the COP27 discussions, biodiversity conservation has been there and is already enshrined in different guidelines at international level. Of course, in the Committee on Food Security, when the countries endorsed the voluntary guidelines on responsible governance of tenure, this was a major milestone, and I think it's very important the fact that these voluntary guidelines are being translated to different indigenous languages in India and also different languages across the world. I know there's a version in Hindi as well. It's an extremely important document. How? Because we already have the framework, the international framework adopted by the countries and the international framework recognized by the different members. Now, what is the challenge? The challenge is related to your second question, and this brings me back to success stories. We have seen success stories when the countries interpret this international legislation and they incorporate it into national policies that can then be implemented for the well-being of the citizens of the respective countries. And on this, we have some blended experiences. The first take-home message I would like to put forward is the fact that we need to improve the work that we are doing in terms of guaranteeing the access of indigenous peoples to communal resources and to the enjoyment of their collective rights. There's a tremendous gap in most legislation in most countries in guaranteeing collective rights of indigenous peoples to the communal resources, the communal lands. We have much more advancement in different countries on private ownership and private management of lands by indigenous peoples, but not necessarily of collective rights and communal management. So this is an area that we all need to improve. Of course, in India, we have the Forest Rights Act that, if well implemented in the different states of India, it could really benefit millions of people only in India, millions of indigenous peoples in India itself. But we have some good experiences. For example, in Colombia, under the peace process, there has been the resguardos indigenas, which is a recognition of collective rights and communal access to for indigenous peoples in Colombia in the process of demilitarization and reduction of violence in the country. We have some positive experiences in Indonesia with the Hutan Adat legislation that allowed indigenous peoples in the country to have guaranteed access to the forest land. And this follow actually a ruling by the Supreme Court in Indonesia, stating that the indigenous peoples in Indonesia were in those forests even before the creation of the present modern state of Indonesia, and therefore had customary rights over those forests, and therefore they should enjoy the access and the titling over this forest. Of course, then the bureaucracy in place and the processes through which these titles are obtained are extremely cumbersome and very difficult for many indigenous peoples across the world. And it's my second take-home message. We will not have more success stories in interpreting the international framework that is there to guarantee the land and rights of indigenous peoples unless we come up with bureaucratic processes that can be followed effectively by indigenous peoples and with administrations at the national level that can guarantee that the rights of indigenous peoples can be followed with simplified bureaucratic and administrative processes. Sometimes the legislation is there, dear colleagues, but the obstacles put forward by the different national and regional and state administrations are such that many indigenous peoples, indigenous women and men across the world cannot benefit from the existing international legislation and national legislation. So it's not only about national programs and legislation, but also it is about effective bureaucratic measures in place that facilitate the process of registration for indigenous peoples. We have some other positive experiences, for example, in Nicaragua, in the autonomous regions, where indigenous peoples are enjoying certain decision-making over the lands and territories. And we have seen that when that is the case, they improve the territorial management, but also the biodiversity conservation. So in closing, I would like to say that while there is existing frame legislation, and I mentioned some of them pertaining to land, to territories, and indigenous people's rights, and while this legislation has been then declined and interpreted at the national level in many countries, and India is a very good example, the challenge is really to come up with simplified processes and to support indigenous peoples for them to register their lands with an special attention that guarantee their access to communal resources and collective rights. Thank you so much for the use of the word, and over to you, dear Ramesh.
Thank you. Thanks a lot, John. And a very interesting point you have mentioned. And this is the one connecting point to the second speaker, Maria Paula, who is now in the land tenure division at FAO. And we know that being a champion and advocate of land tenure, UNFAO is a significant focus on VGGT, which provides a paramount opportunity for reversing the gender injustice related to the land ownership of women. Gender equality in the VGGT is at the core of all processes and aspects of tenure governance, including policy formulation, institutional setup for the administration, service provisioning, land administration program, and more importantly, access to justice. So, Maria, question to you is, how would you see that VGGT as an instrument for establishing the gender relation over agricultural land and promoting more gender equitable governance of land tenure, and where you can see the real success and learnings of VGGT, which could be replicated in other parts of the world? So over to you, Maria. Thank you.
Thank you. Thank you very much, Ramesh. Thank you for inviting. And just you have already briefly introduced myself. I am also working with Jon in the Indigenous People Unit. Now, back to your question. You know that gender question has several facets, we can say, some of them being included in the VGGT, whilst others were not. As you know, the VGGT in the presentation includes a specific gender point where the enjoyment of all human rights is recalled, while the accent is specifically put into the question of access to land. In that section, it is all called that women should have equal tenure rights, but without clearly specifying whose rights are we specifically talking on. So this is why we have to refer to also to other documents where it can be found a definition on to specify that, like for instance, the one below, that land tenure rules define the ways in which property rights to land are allocated, transferred, used, or managed in a particular society. Now, specific attention, in my opinion, should be given to the word managed. In FAO, the management of natural resources, particularly land, has always been a separate issue from the tenure one, considering the first as specifically related to agronomy science. In this sense, we can interpret this call for equal management rights as a wish to see both men and women equally participating in the definition of what should be cultivated in a given parcel and how. But nothing is said in the VGGT on how the decision-making process concerning the sharing of the final product between sufficiency and selling to the market. Now, this gray area is considered to be a prerogative of a particular society, and the VGGT do not want to interfere in that. Similarly, under the cover of respecting community rights, VGGT does not say anything on women-specific individual rights within communities, and in general, how to accelerate social dynamics toward reducing the weight of the patriarchy. So we all know that the reality in the South, patriarchal domination is a must, not only in the land tenure, but in the overall men-women relation in the economic and social and sphere. Community tenure systems are not static social arrangement. They move in one direction or another, depending upon external or internal power relationship and stimulus. Today, power relations are almost everywhere in favor of men. Governments, institutions responsible for natural resources, formal and informal level, are in the hand of men. As such, they tend to maintain, replicate the patriarchal approach that limit any real advancement in terms of gender equality. So we can identify two types of limitation with the VGGT. One refers to the content that avoid touching any critical issue like power relations. This limitation cannot be overcome because the text is like it is. The second limitation is vis-a-vis the players like FAO that have promoted the VGC process. But at the end, we have considered this as a document pertaining to countries. As said before, gender unbalanced power relations are clearly expressed in customary system. And if no important players like the UN agency is not promoting in a proactive way a genuine interpretation of the call for gender equality, meaning touching the core of the problem, which is patriarchy, it is virtually impossible to expect real change in gender relationship. Now, going back to your initial question, Ramesh, the answer goes in the direction of the promoters of the VGGT rather than on the text itself. The simple insertion of the VGGT recommendations into national policies of legislations, as also Jon mentioned before, about policy legislations, if they are not made effective, is not enough. So this will not ensure any positive result at all. If the asymmetric power relations are not changes, this promotion of the VGGT might be rhetoric, superficial, in other words, smoke and mirrors. What is needed on the top of this is the promotion of the VGGT principles is to make a different, proactive and more prolonged activity by international players and agencies. I insist on the critical role for the neutral player because touching tenure and governance of natural resources means entering into a delicate domain where national sovereignty is at stake. Now, the VGGT may provide important direction and references for possible policies and laws, but they are certainly not the tool to reverse gender relations. So gender roles and relations are almost always the fruit and sign of inequalities and systems of oppression and marginalizations that are embedded in the framework of land systems, especially customary ones, which are complex and, as I said already, not static. Therefore, to change gender relations in a direction of equality and equity, there is a need for approaches that are rooted in a deep understanding of the context of power dynamics, social and gender norms, approaches that accompany the implementation of programs and policies with interventions aimed at changing the social and gender norms that reproduce discrimination and marginalization of women, but not only women. In short, merely technical approaches could not reverse gender relations, but there is a need for a more proactive role if we want to translate those principles into real and structural change. Thank you.
Yeah, thanks a lot, Maria. Very important points. See, I mean, in spite of a lot of very interesting hope in and around voluntary guidelines for land tenure, still is a voluntary. At most of the stage, by choice, sometimes they adopt some of those provisions, but most of the time it's absent. So let me switch over to Carla, who is a lawyer, and she's a director of People, Land and Resources in CIEL, the Center for International Environmental Law, based in Washington, D.C. So Carla, the vast majority of the world biodiversity and most of our natural resources like timber, mineral, and oil, are found in the lands of indigenous people. And this is the truth, this is the reality. Today, the land rights of indigenous people have been routinely plundered and polluted by the government and the private companies. How can international legal framework, I repeat, the international legal framework, help the indigenous people to ensure the recognition and protection of their rights as natural resources? And my second question is, while protecting the indigenous land rights is essential, there are still challenges to the ensuring land restitution after indigenous territories have been lost. How can international framework be used to re-establish the space for land restitution? So over to you, Carla.
Thank you. Thank you so much, Ramesh. And hello, everyone. It's very good to join you at the conference, and thank you so much for the invitation. Taking advantage of being the third speaker, I want to definitely keep going into the direction that Ramesh, Yon and Maria Paula have been going. After mentioning the many instruments that exist already in international law for the recognition, for the protection of land rights, for the protection of indigenous rights, within the context of one of the cases, one of the communities that CIEL, the Center for International Environmental Law, has been accompanying for several years now. This is an indigenous community, the Nave Bugle community in Panama, that has been living in the Atlantic coast of Panama for thousands of years. They are now, we've been hearing a lot more of how indigenous communities are the stewards, you know, all these academic reports recently. Well, they've been protecting that tropical forest for thousands of years. They depend on it for their lives, their livelihoods, their food, their health. They use medicinal plants that are everywhere in their territory. And they've been struggling in recent years as they've seen a lot of migration. A lot of people have been leaving. So they have wonderful environmental human rights knowledge in the community. So Feliciano Santos, our partner, and Olinda Castrejon have been really leading and trying to educate the younger indigenous community to understand the value of staying in the community. And so as an example of really in practice, how we've been supporting them to be able to use the international legal framework for the protection of their lands is something that I wanted to share. So they've existed in this area. Panama has been carrying out a lot of infrastructure development for liquefied natural gas, energy infrastructure, and the creation of transmission lines. A transmission line called Transmission Line 4 is planned to be constructed 300 kilometers along the Atlantic coast of Panama. And coincidentally, there is an investment from the private lending arm of the World Bank, the International Finance Corporation, to support the state-owned electrical company, ETESA, in the bidding process, in designing the project itself, in helping to actually create this development project. So they've invested million and almost $2 million in Panama for the creation of this transmission line, and have been supporting the Panamanian government on how to create this transmission line. But along the way, they have not been carrying out proper recognition or acknowledgement or inclusion of indigenous communities that are on this land where they expect to put this transmission line in the decision-making. Namely, they haven't respected their right to free, prior, and informed consent. I will note, and I know that Yon mentioned this, Panama hasn't ratified ILO 169. And this is a major obstacle, obviously, but there are other legal instruments that Panama has signed on to, and there are specific laws. So I go to what Yon was saying of the creation of domestic national legislation that takes on those international instruments, no? And so since 1997, the indigenous community itself was recognized, the comarca, as they call it, the indigenous territory of the Nave-Bugle communities, indigenous communities, was recognized. And law, and this is something that Feliciano and Olinda, they know the numbers, they know the laws in their own country. Law 37 recognizes the right to free, prior, and informed consent, even without having ratified ILO 169. And because of that, and this money coming in from the World Bank, there are policies within the World Bank that respect indigenous people's rights. As Ramesh knows, we've been involved with many other civil society organizations trying to get specific human rights language into World Bank policies. That has not been completely successful, but there are principles that the World Bank has been adopting, has been putting into its policies. All this to say that we at CIEL supported the community to bring a complaint to the accountability mechanism of the International Finance Corporation of the World Bank, the compliance advisor of ombudsman known as a CAO. And when we presented that complaint, we used those principles, we used those rights. We presented the lack of implementation of that free, prior, informed consent right, of the protection of these indigenous communities, of their recognition to the land and to their land tenure as reasons why the project was not being proceeding appropriately. And I will note that the indigenous community is not against the project. They merely want to be consulted about still to this day, the route, what is the route that transmission line and where exactly would it be placed? Because they don't want it obviously to interfere and to jeopardize their way of living, as there have been other transmission lines that have been very damaging to communities. And then bringing in extractive projects such as mining projects, et cetera, to the region. And so within that process, as we've been waiting for that process, we also went to other fora to use these same international standards, international principles, and international treaties and agreements that Panama is a signatory to leverage. So not only were we using the accountability mechanism of the IFC, but we also reached out to the Universal Periodic Review of the United Nations Human Rights Council to bring the same situation, the same preoccupation and concerns of the indigenous community to the Universal Periodic Review. We also presented, and Feliciano spoke directly to the UN Committee on Economic, Social, and Cultural Rights. We reached out to UN Special Rapporteurs on the rights of indigenous peoples, on the Rapporteur on Human Rights and Environment, the Rapporteur in the field of cultural rights, reaching out to all of these different rapporteurs at the UN level, telling them what was happening, and even being able to have some conversations with some of these rapporteurs at an international level about a very domestic issue. The communities also have presented the situation and reached out and used the same instruments and highlighted the same instruments at the Inter-American Commission for Human Rights. They've held thematic hearings. We've supported them in thematic hearings while also reaching out to rapporteurs of the Inter-American Commission, specifically the Rapporteur on Indigenous Communities, again, the Rapporteur, but at an Inter-American level on economic, social, and cultural rights, emphasizing how this project may jeopardize the community's right to livelihood, their access to water, their access again to medicinal plants and food sources, etc. And obviously the rapporteur in charge of Panama at the Inter-American Commission for Human Rights. So all this to say that communities, as many communities around the world, and reach out to many different sources and fora, any available fora, to highlight their situation. And this highlighting of the problem at many different fora is a way in which they have been able to continue to protect their land. So I believe, I'm trying to summarize now, but all of this all of these international instruments have been leveraged by the community in Panama to highlight the situation. And that led the Panamanian government to pay close attention to the situation. They didn't expect to have the UN office of the High Commissioner reach out to them via rapporteurs. They didn't expect the United Nations Human Rights Council through the Universal Periodic Review to actually include the situation of the Nave Bugle communities and specifically the transmission line and say, how are you handling this situation? How are you actually going to guarantee the community's right to free, prior, and informed consent within this transmission line project? So that has come back specifically to the community that had in a moment where domestic litigation had not been successful, where even communities trying to reach domestic litigation options are dismissed. Cases are dismissed because they're not recognized, or they are criminalized, or the sheer time or cost of domestic legislation is so high. But this has been able to be achieved. They have been able to still protect their land in a project that was meant to go forward. And I think we all recognize that COVID delayed a lot of this project, and the bidding process has yet to happen. But the bidding process was supposed to happen in 2019, and we're in 2022. So all of these different fora where the community knocked on the door, spoke to rapporteurs, communicated via Zoom in a call with the Committee on Economic and Social and Cultural Rights, has had an impact, has created waves in Panama, where the government of Panama is well aware that the Nave Bugle community living in this area in the north on the Atlantic coast is exactly aware of their rights, is exactly aware of how to protect them, and has put them on alert that when this bidding process is finally happening, and it's gone again very slowly, the success in the case that we filed at the IFC, which recognized failures in how they were instructing the state-owned electrical company of how to do this process with indigenous communities, has now been put on alert as well. So all of this to say that even when specific legal instruments haven't been put, again, we were very concerned that ILO 169 had not been ratified by Panama, yet other instruments and other sources of law have been tremendously helpful for Olinda, Feliciano, and the indigenous community in general to be put in practice, and by using different fora, again, the UN system, the Inter-American system, and other accountability mechanisms have created this wave of awareness that has continued to protect this territory to this day. So I will leave it there, Ramesh, and happy to hear more and continue with the discussion.
Thank you. Thanks a lot, Carla. And you are exactly at this point which is a reference point for India, because India is also one of those countries which completely refused to ratify ILO 169. So we have one speaker, our very dear friend from Center for Policy Research, and she's one of the architects of Land Rights Initiative, who did a pioneer research work on mapping 1,000 land legislation, a very extensive research work in the constitutional provision of India called the Fifth and Sixth Schedule provisions. as well as the understanding the whole scope and the new realities of Land Acquisition Act of 2013. So welcome, Lalita, in this panel. I'm sorry to bother you in the last minute to come and be with this panel. So coming to India, India is a little reluctant to learn anything from international framework. But in the same time, we have a very specific constitutional provision of 5th and 6th schedule, which actually recognize in principle the local governance. Where you see the space and scope of integrating international framework, if it's necessary, in the 5th and 6th schedule area, or the vice versa, take the key lessons from the 5th and 6th schedule area and to advocate for some sort of international framework. So this is one of my one question. The second question is provision like FPIC, environmental impact assessment and social impact assessment introduced in the Land Acquisition Act of 2013 are really effective on the ground. So over to you.
Thank you, Ramesh. Good evening, everyone. Thank you, Ramesh, for organizing this panel. As you said, you're going to listen to everyone anyway. So why don't you come and join us? So, and thank you to all the panelists for sharing, so many interesting and important insights about the ILO Convention 169 and the difficulties with sort of following those principles in countries that have not ratified the convention, and India is one of those countries that have not ratified the convention. But prior to that convention, we have the Convention on Indigenous and Tribal Populations in 1957, Convention 107, which India has ratified, and the goal of this convention was to protect the religious, civil, and social rights of indigenous and tribal populations within an independent country. And that is the stand that India has always taken with respect to the tribal populations within its territory. So just to give a bit of the historical background, the British state's policy of towards the indigenous communities in India was one of identity-based isolation. So as per the Scheduled Districts Act of 1874, which is for the first time when they legislated to regulate their relationship with the areas which they call the scheduled districts, within which these were tribal majority areas. So the idea was that you keep these people away from the rest of the Indian population. But of course, because the scheduled areas, as our research has shown, the one that Ramesh referred to, is that are pretty much very, very coterminous with the forested areas. And because the British state enacted a series of forest laws even before the Scheduled Districts Act from 1868 onwards, 1868, 1878, so on to 1927, a series of forest laws were enacted. And those laws basically allowed de-recognized all the rights of the forest dwelling indigenous communities and allowed the state to go in to do what they wanted to do in terms of timber and other things. But first law from 1868 recognized the rights to collect forest produce of tribals. Then those rights became privileges and concessions as the legislation progressed. So gradually those rights were de-recognized. And what we have seen post-independence and so the Indian Constituent Assembly started drafting our constitution in 1946. It was elected. India became independent in 1947. So over a period of 2.5 years, till 1950, when the constitution was adopted on 26th of January, they drafted a series of, it's the longest constitution in the world, spread over 300 articles. And within the constitution, what we know as Article 244, which creates the 5th and the 6th schedules, and read with the 5th and 6th schedules, creates a sort of autonomous provisions for autonomous governance of these areas that have been designated under the 5th and the 6th schedule. So the 5th schedule applies to tribal majority population within peninsular India. So it applies to 14 states that have tribal majority populations. But these are tribal minority states. So the entire state, within the entire state, the tribal population is in a minority. But in those areas where the schedule is applicable, those districts that have been unified, the tribal population is in a majority. And then you have the 6th schedule, which applies to tribal majority population in the northeastern states, where we have 4 states that have been identified. And of these states, the tribal population is in a majority, generally relative to the rest of the population. One of the states is Meghalaya, where the entire state comes within the scheduled area except for the Shillong township. Now, we have these very progressive 5th and 6th schedules, which have been enacted as early as 1950, even before Convention 107. So India is a pioneer in terms of recognizing the important, areas of the need for autonomous self-governance of these areas, and which many countries in the world did only post convention, the 169 in 1989. Only after that, many of the countries have created special protections for indigenous people's rights. But as we can see that the thinking for the all these issues evolved greatly between 1957 and 1989, and because India did not really ratify the 1989 convention, therefore our protection of indigenous people's rights at the constitutional level has been frozen within the terms of the 5th and the 6th schedule. But at the legislative level, due to continuous people's struggles for greater autonomy, we've had the Panchayat Extension to Scheduled Areas Act, which was passed in 1996, and then the Forest Rights Act, which was a reversal of the historic injustice wherein rights of tribals from 1868 were diluted to no rights, from rights to privileges and to concessions to no rights. Again, it has been asserted in the language of rights. However, as Rameshji knows better than me, and I often speak to him on how this law is being implemented, there are many challenges in terms of implementation of the law, because the law has been enacted against the backdrop of still existing forest laws that under which the state still exercises control over all forest land, where the Forest Rights Act is now being used to recognize the rights of the people. So there is a lot of resistance from the Forest Department. In the beginning, they were not even willing to accept the law. Now, of course, with the work of civil society groups, and there has been a lot of progress that has been made, but we had a panel in the morning where we also had Amrish Mehta from Ashwani, who was talking about how, even if 50% of the claims are registered, it is a success because of the kind of resistance that we are facing from the Forest Department. So those are some of the progressive laws. Then we have the 2013 Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act. It's quite a mouthful, so we call it the CTLARR Act. But some of the principles again that we have been talking about, you have free trial, informed consent. Prior to this law, we had only in the form of delegated legislation, we had the EIA notification. This is the Environment Impact Assessment Notification, which was pursuant to which you had to do an environment assessment before any consent was given for go ahead for a project. But there was no impact assessment on the people who were there. So some states, some projects, it was the government's discretion. If they want to do it, they can do it. There were certain states which had some policies regarding social impact, but it was not a legal framework. It was not a binding obligation to do a social impact assessment. So it is after this 2013 Act that has been passed, it has a detailed framework for social impact assessment as well as for rehabilitation and resettlement. Again, under the previous land acquisition law, it was possible for the collector to rehabilitate and resettle. It was there, but it was a discretionary power. It was not a mandate. And we know what happens when there is no mandate, then it doesn't happen. So this law is very progressive because it repealed and replaced a 120-year-old colonial law and provided this new framework. But again, we have seen a lot of pushback against this law. As many as 20 states have now amended. So the law came into force in 2014, we are in 2022. Within the first 5 years itself, most of the states had actually amended the law to eviscerate it of its core content, basically to exclude the social impact assessment and consent requirements, which from the international standards had been incorporated. Those requirements were actually excluded for the bulk of the projects. So in that sense, the very progressive law is eviscerated of its core. Changes were made. In keeping with the spirit of the law, it is not clear whether there be the judiciary may at some later date pronounce on whether these amendments are actually correct or not. There have been some pending litigations on these issues. But so far, the judiciary hasn't taken a very people-friendly approach. And the one constitutional that has been cited, which applies to pending acquisitions under Section 24 of the Act, which had a retrospective effect. the Supreme Court Constitution bench in 2020 actually did not relocate to Pune. So it is not so much that we are expecting the revision. So on this one that I like to take on the tribal question on the rights of women, basically what in my research I call in India at the time of independence, there was a population which was 60%. Was constituted 60% of India's population, but this includes women, indigenous people, and Dalits. Dalits are at the bottom of the caste hierarchy in India. Level and the two things are in fact quite, there are distinctions, although in terms of the level of discrimination there are similarities, but there are serious differences as well. So the caste system is unique, and the Dalits have been at the bottom of the caste hierarchy, and they were excluded from the possibility of owning land and property, and they continue to be the most standard. And same with women, women did not have the status. Women, in fact, for women it is similar across the world in the sense that women themselves were property. Now, again, in the case of women, India has been a pioneer because India gave all Indians, including men and women, the right to vote when we became independent in 1947 itself, to the extent that this was before all women in England had the right to vote. So only women up to the age of 30 and those who were owning property, they had rights to vote. So universal adult suffrage in many parts of the Western world only came after India and actually given universal. So that was a very big and transformative movement for our constitution. I think one of the reasons for that is that the constitution was drafted by Dr. B.R. Ambedkar, who was himself a Dalit. And the constitution included Article 19(1)(f), which provided a fundamental right to acquire, hold, and dispose of property, which right was available to everyone. For the first time, all citizens could acquire and hold property. Before that, everyone could not do so. And although these rights were later abolished, there's a long history to that, thing which I have worked a lot on, but there isn't time to talk about it here. But this thing, along with these constitutional framework and the Hindu Succession Act of 1955, 80% of India's population is Hindu. So, these laws really work towards ending the discriminatory framework that existed between the rights of men and women. But there have been amendments to these laws in the millennium, which have further, democratized the ability to hold property. But still, there are many, like Shikha Deo's work, Virendra Dave's work have pointed out, that still with respect to owning and inheritance of agricultural land, there are still distinctions between different classes of heirs, including married daughters and unmarried daughters and so on. So a lot of work still needs to be done in order to implement the CEDAW principles that require us to ensure that no one is being discriminated on the grounds of sex or gender. And similarly, in the morning, we had a discussion on the rights of transgender people, that there are many issues with respect to inheritance rights of transgender people as well. So to that extent, we are still complying with the international principles as that is laid down in CEDAW.
Thank you. Thanks a lot, Namita. We can take maybe one or two questions, but before Jan, we actually want to leave because we have to participate for some other convention. So Jan, after listening all these four speakers, there are some very interesting experiences, some learnings, which is actually emerging from different parts of the world. So where is the hope? If there is some kind of international good framework which actually talk and protect the land rights of indigenous people as well as the women, some other marginalized community, but at the same time, the practical execution is still the big challenge everywhere, especially in the global south. So where do you see the hope? So over to you, Jan, and you have 2 minutes to say, and then I'll switch over to the audience for one or two questions. Jan, please.
Well, thank you so much, Rajesh. And my apologies that I cannot be in India with all of you to have a discussion, because the discussion is very relevant and very timely and extremely important, because it affects more than almost 500 million people across the world. If we put indigenous peoples in a single country, that will be the third most populous country in the world. So we are talking of a huge segment of the population that is understanding development, is understanding food systems in a different way than many other communities and peoples do, but that they merit the same level of respect. I want to pick very briefly on something that Carla Garcia said, which I think is extremely important, and is that Many countries have not recognized or have not endorsed ILO 169, but yet they are doing great progress at the level of national legislation. You mentioned Panama, and is one of the good examples. At the same time, some of the countries have endorsed ILO 169, and then we see the killing and the displacement and the forced eviction of indigenous peoples daily. So there's not a direct relationship between the endorsement of international framework and then a better well-being for indigenous peoples. I think one of the important opportunities is related to the climate change debate. I think if we looked at the world and we overlap maps of ecosystemic value and biodiversity, maps of linguistic diversity and culture, and maps of indigenous peoples' territories, we see that tremendous coincidence in these lands and how they overlap. So the way forward, in my humble opinion, is to start recognizing indigenous peoples as the guardians of biodiversity and the real fighters against climate change. And to do in this recognition, not only recognize their rights, but also recognize their distinctive governance systems, like Maria Paula was mentioned, the distinctive cultures and languages. And in this recognition, acknowledge the vital role that they play in biodiversity conservation for the well-being of humankind. And that can be done in a way where peoples live, where biodiversity is thriving, can be preserved through this recognition to maintain their well-being. So guaranteeing their access to these lands has to start with their recognition and then with putting instruments in place by the governments that guarantees their access to land and that this global discussion that is taking place of protecting large surge of the earth to combat climate change. That will be my suggestion on the way forward. Thank you so much, Ramesh.
Technical issues for another session, or there's no time for a question?
Actually, there is another session in 15 minutes, so we
In
have
15 minutes, okay. So if you allow me, sir, I mean, I'm really tempted to give mic to at least watch sir, if you want to say something, because you have this. Researcher who did extensive work, wrote several books, several research notes. He's based in the northeastern part of India. So over to you, what's that?
Thank you, Ramesh. In the Northeast, we face sort of, we are in a dilemma on the indigenous issue. On one side, there are the customary laws, which are recognized constitutionally in 2 states and by the 6th schedule in some other places, which give the indigenous people, the tribals, right over their land, their resource. Under which they manage their land, do not allow women to own land. So while we support the customary law, we are also caught in the trap of not recognizing women's rights. And that's becoming very difficult because, in fact, we have done studies on the gender implications of customary laws of 2 tribes in each of the 7 states. And that comes out very clear. Now, how do we manage that? How do we deal with that contradiction?
so the mic. Could you place it closer to him?
Did you hear?
Yes.
No.
Someone pointed out they were not.
Oh, I see. Okay. Did the panelists hear?
Yeah. Now.
have a question. So which law prohibits one from owning land? Which law prohibits? Customary laws. Is it written laws, sir? Customary laws? No, customary laws are not written by their very definition. Then how do you?
So,
Custom itself says
let me ask the other panelists for their concluding remarks.
Yeah.
So I first want to come to Carla. Carla, where is the hope?
And I hope I'm hearing you correctly. Some of the parts I was missing, but did you ask where is the hope?
Yes.
Yes. The hope. Where there's the hope, and I can see you in the audience as well. I think I'm hopeful when I see truly that, and this is, I mentioned the example of our partners in Panama, but indigenous communities in Peru, I'm from Mexico, so indigenous communities throughout Latin America, Peru, Colombia, Nicaragua, are so, I mean, they, for years now, not only are they tremendously eloquent about their relationship to land and the way of living, really trying to explain to the rest of us what this very essential link to the land and their way of living and their spiritual connection to the land is, have become complete experts on the international legal frameworks and can put them on the table and say, look, when you talk about this, this connects to our way of living in this way. And that to me is very hopeful, because even though they're not putting aside their beliefs in any way, by any means, but they are using the tools in a way that speaks to institutions more clearly. And one example, again, I turn to to the examples with Feliciano. My colleague Sarah Dorman is the one who works closely with Feliciano and has been working with the community for many years. So when we help to draft these submissions to the human rights treaty bodies, et cetera, we put it in human rights language, et cetera. But then Feliciano will say, no, you need to tell them that this and this and this. You need to tell them that our relationship with land is this, and that our existence in this territory is what's allowing this biodiversity, exactly what Yon was saying, is what is allowing this community to exist. And that, I think, is where the hope lies, that indigenous communities are on a daily basis connecting those international principles, those international standards to their reality, and holding us to account, to use their language in these very philosophical, standards and even voluntary standards. They're saying, no, actually, this is a reality. And this does speak to their reality, but this is how we live. And so it's crystallizing in many minds, I think, hopefully, the value of these international legal frameworks and how they can be used to protect their land, their territory, their livelihood, their water definitely, in a way that is finally recognizing that stewardship. And that makes me very hopeful. And even with new treaties, for example, I just wanted to leave on the table the Escazú Agreement in Latin America that is similar to the Aarhus Convention in Europe, because it protects access rights, access to information, participation, and justice, but it is the first binding instrument that includes the right of environmental and human rights defenders and how they need to be protected. And that's a piece that specifically speaks to what Yon was saying of the criminalization of environmental indigenous leaders throughout Latin America that are trying to exercise their rights. Even that has now been recognized. And that's something that we would not have expected in Latin America, where so many of these unfortunate deaths are happening as well. So I'll leave it there.
Thank you. Thanks, Carla. And sorry to Namita and Maria Paula, because we have to cooperate with the technical team because they need to prepare for the next session, which is, I think, going to start in next 5 minutes, 5 to 10 minutes. So my sincere apologies to Namita and Maria, but I know that until unless we are on the ground and we are in the community, there is a hope. So thanks to audience, thanks to speakers, and thanks to all of you who are actually joined online. Yeah. Thank you.
Thank you.
Thank you so much.
Bye.
Bye. Thank you. Be well. Be well.
Yeah.
Thank you. Bye.